Yes, hello. I'm attorney Justin Sterling. This is Coffee with a Lawyer. I am a personal injury and business lawyer. This is your chance to ask your lawyer your questions for free. Ask the lawyer your questions for free. We're streaming live on the digital airwaves of YouTube, Facebook, Instagram, and LinkedIn. This is why I do what I do, to help people with their legal issues, improve their lives, and make a meaningful difference. Please know that there is no attorney-client relationship here, no confidentiality, because what you could say here could be discoverable in any legal matter. So I encourage you to keep your questions or comments general. This is just for educational purposes, general information, and is not specific legal advice. If you need to speak about a specific matter, I encourage you to reach out to a lawyer and schedule a confidential consultation. Um, and today we have a few special guests. If you are viewing online, please feel free to ask any questions in the chat and I'll do my best to get to it. But I would like to give the opportunity to Doreen to ask her question, give me some factual background, and we can discuss your situation. I could spot the legal issues, give you an analysis, and perhaps give you a action plan.
Okay. My case would be from the internet affiliated marketing about people that joined from all over the United States and Canada. And that I was wondering what kind of lawyer would I be looking for? Business, internet, civil?
Understood. Yes, thank you for sharing. Well, you may want to consider a class action if there is a number of plaintiffs with common legal issues. There must be numerosity and a risk of multiplicity of suits so that you can file a class action. Now, is a class action the best way to go? Perhaps you may be able to get more recourse if you pursue an individual action. Even though there's a class action, that doesn't mean you have to join the class. You can still pursue your individual rights. But in terms of a class action, you guys can combine your resources. If you were to reach out to a class action attorney, you could serve as the class rep. Now, there are some responsibilities with the serving as the class rep. You will have to sit for a deposition, which could take up your time, your energy, and it could be a difficult situation. You will be interrogated by the opposing counsel, and that's not a fun situation.
Right.
Yeah. You will also have your name on the pleading, and some people don't want their name exposed on the public record. So those are some considerations. Also, some people are eager to serve as the class rep because they want to pursue justice. There is also some additional compensation as the class representative. It's not substantial, but there is a little bit more compensation, but it's nothing substantial. So those are some considerations. Misrepresentation, breach of contract.
Okay. Another question. With a class action lawyer, would he be eager to sell, sell us out and settle faster? Or?
Well, that's a good question. You bring up a good point, because with the numerosity of plaintiffs, there is a risk of more exposure. So it could leverage the case against the defendant. Whereas, an individual lawsuit may not be that risky for the defendant. And also, you're going to want to check your terms of service when you signed up for this class. If it was online, it's going to be those online terms that you may have clicked through they are legally significant. You may have agreed to an arbitration provision. An arbitration provision may prevent you from filing a lawsuit and also joining as a class member. So it restricts your legal rights. That's something you want to be aware of. Arbitration provisions are difficult to overcome. They are, yeah, they're a tool for businesses to limit their exposure. They don't want to have class actions filed against them because of the risk of exposure, the risk that they will have to pay widespread damages.
Right, well, this guy needs to be out of business. He's a scam. We signed up with, Federal Trades Commission. We all sent in a,
Well, it's not uncommon, especially with the online digital age, where where the reach is really limitless, and the type of the reach that they can have to attempt to exploit people is it's unfortunate. You may want to consider a class action, but you have to check those terms of service. It's likely there's an arbitration provision in there and a waiver of class action membership.
how about contingencies?
It could be a contingency fee. If you want to consult further on this, I would have to get more information, more background about the potential defendant. There's a lot of evaluation into contingency basis representation because it's a risk for their attorney as well. Class actions are generally contingency fees.
Okay,
Yeah.
all right, no, I'll let you go to the others that are waiting.
All right. Well, thank you for your question. Please feel free to reach out. I'd love to learn more about your case. This may not be the proper platform to go into the specific details because of the confidentiality.
All right, are you serious about me reaching out?
Yeah, absolutely. Please. I'd love to learn more.
Thanks, buddy.
I'll put my email in the chat. Email me some information and I will review it more.
Okay,
And also, if you are happy with what we discussed here, and I know this is just the tip of the iceberg, more will be revealed with legal matters. They're complex. But if you feel like you have gained a little bit more insight, if I've been helpful, a great way to say thank you would be to leave a positive review. And I also will put my review links in the chat as well, if you would be so kind to leave a review. Although you're not required, it's just, I really do appreciate positive reviews. And,
sure, I appreciate your time, buddy.
Yeah. Let me put that in the chat for you. And feel free to stay logged on here because you could learn from some other people's situations. I do believe we have another attendee, Subhash, who may have a similar situation. Breach of contract, fraud, misrepresentation is quite common. So stay logged on and you may learn some more.
Okay.
Subhash, would you like to tell me a little bit about your situation?
Sure. I got engaged general contractor for remodeling my house, and the contract value was like $220,000. So it's a significant work. It lasted about a year. During the first 3 months, it was identified that the foundation, there was foundation issue, and he asked me for another $20,000 for amending the foundation. However, in the contract, it clearly says that it includes that functionality. Also, on the blueprints that city approved, there was a warning for the contractor to ensure that the foundation was matched with the existing foundation. To cut story short, he basically billed me an additional $20,000. And apart from that, he was supposed to provide me all the receipts and hours for the new work that he did, the change orders. The change orders were in the amount of $45,000. And he misrepresented it, gave me false receipts. And also, I found his employees drinking on site, which was a safety issue that I had raised with him. As well as there are about $40,000 worth of quality issues that he has not completed, although he has agreed to.
Yes.
So I filed a complaint with CSLB, and it's been 9 months. Nothing has come out from that. And then I filed with their bond company, and they are also dilly-dallying, trying to ask me more information, this, that, and they want me to do the investigation and give them the report, or they are waiting on the CSLB report to determine their maximum liability. So my question to you is, how reliable CSLB is, and how their conclusion would help me recover some of my losses. Secondly, the bond company is supposed to independently investigate themselves rather than depend on CSLB. That's how I have understood. But they insist that they will not do anything until they get the CSLB report. So it's like going in a loop. So my next, my thinking is that I should file a complaint at least in the Superior Court and get my statute valid until these things get sorted out. The question to you is, how does this bond company work? Are they compliant if they do not follow their procedures? Is that a breach of compliance on their part?
Good question. You bring up a lot of issues in your fact pattern. I would say the first priority is your statute of limitations. So I think you are correct with filing a lawsuit to preserve your rights. I don't know when the dispute arose, but generally with a breach of contract, I believe a written contract, you may have 1 or 2 years. You have to research the statute of limitations. You want to preserve your statute of limitation. That's always priority. So you don't want to blow your statute of limitations. All these complaints with the board, the the CSL board, and that's all fair, but your rights get adjudicated in court, and the legal obligations are imposed once you file a lawsuit. That's when they have to respond to discovery under oath. They're obligated to answer you. They have to file an answer. I don't know with this industry in terms of the general and subcontractor, licensed contractor industries. I'm not too familiar with how they are regulated. It also may depend on what state you're in, because state laws may have control over how they're regulated. The licensing board, if you have to exhaust administrative remedies before you have to file a lawsuit, which I don't believe you do. I would just file a lawsuit. And
Okay.
I don't know if you filed yet or not. Did you?
I haven't yet, and I've read for California, it's 2 years. Statute is 2 years, so I still have time. The dispute arose in February of 2025. So we are within 1 year even.
Okay.
I file tomorrow.
Yeah. All right. February 2025. Yes. Agreed that you may be within the statute of limitations, but however, it is my practice not to make the statute an issue. You're getting close. And I
Right.
know it may be 1 year or I know there's a difference between verbal contracts and written contracts. You know, what is actually being sued on for this case? Is it the written contract? Is it verbal agreements? I don't know. I would not want it to be an issue. I always file,
Sure.
way safe to preserve the statute of limitation. I just don't like to have that to be an issue. There's also different arguments you can make about tolling and discovery. But again, I don't like to have that to be an issue. I'd rather just be safe and file my lawsuit without any grounds for defense. Now, as far as the bond company, I'm not too familiar with how the bond company works. Is it serving as some type of insurance? Are they putting some money up for any type of foreseeable breach? I'm not sure. I'm not sure how this bond company comes into play with the contractor subcontractor relationship. Yeah, go ahead.
Yeah, in order to be a licensed in California with CSLB, they are required to have a bond
Right.
of maximum of 25,000, which is what they have, has been verified. And
right. So
so
if they're operating without a bond, do they have a bond or not?
they have a bond.
Okay.
And I have been communicating with the bond company, who is also trying to delay the whole process to pay me back, because gave them several estimates from independent contractors. I got independent contractor evaluation done and sent it to them. And they, in principle, have agreed to the payment, but then their principal, the contractor, objected to that. And therefore, bond company came back to me, said, we are waiting for CSLB to verify these facts. But when I talk to CSLB, they are saying that the bond company should do their own independent investigation. They should not be depending on CSLB's investigation.
Fair. I think you would be best served if you just file a lawsuit. Now, the way you plead your complaint, you're going to have breach of contract, and you're going to have fraud and misrepresentation, because those torts allow you to also seek punitive damages. Okay.
Right. I have put together a rough draft of a complaint, and I put breach of contract, negligence, fraudulent misrepresentation as cause of actions, and civil conspiracy between two contractor and subcontractor, and then a bad faith violation of statutory duty for the bond company. So I'm including bond company as a defendant in this case.
Okay. I don't know if those would be the causes of actions I would allege. I'd have to review your fact pattern, but civil conspiracy always, somewhat I'm discouraged by civil conspiracy, because you want to present yourself in a position of honesty and credibility, and that type of cause of action, it's just looked upon with skepticism. Civil conspiracy, like, it's very difficult to prove that. You got to prove a case within a case, essentially. I've alleged different type of conspiracy claims, RICO claims. They just always kind of complicate the case. As a plaintiff, you really want to present your case very straightforward, clean cut, breach of contract. I like your breach of contract and fraud misrepresentation. Okay?
Okay.
Civil conspiracy just kind of throws a wrench in it, and it's going to end up being like a red herring when you try to lay out the proof for your case.
Okay. Just an example I give you on this, that foundation overcharge of $20,000 was done through a subcontractor, another company. And I asked for the proof, and they gave me a receipt, which was like manufactured receipt given by one subcontractor to this contractor, and that's fraudulent. That's why this they conspired to charge me 20,000 more. That's where I'm going with that.
Understood.
But I take your point that this may be make it a lot more complicated.
I'd have to evaluate your facts more thoroughly to properly evaluate it. I'm happy to review your complaint if you want to send it to me. This is not a contingency type case. So,
Right.
and we can discuss offline any fees. I'm reasonable, I'm negotiable, but I'd like to be of service. So please feel free to reach out. I will
Okay.
also put my phone number in the chat, so you guys have my phone number.
Yeah, I have. I have known you for a few years now.
Oh, great. Well, thank
We
you.
consulted you 3 years ago, I think.
Great. Well, thank you for signing back on and staying in touch. I'm happy to be of service.
Thank you.
Well, thank you. We also have a few other attendees. Let me
Sure.
check the chat to see if anyone's okay. Let's see here. All right. We have 1/526 as a profile. Can you hear us? And feel free to ask a question. Mic check. Yeah.
Time with a commendation.
Yes. I'm sorry, we're having a little bit of audible issues here, but yeah, feel free to listen in. And if you want to type a question, that might be of better help and I can be of service. But we also have Jared here. Jared, if you'd like to ask a question.
Good morning.
Good
How are you
morning,
doing,
Jared.
Justin?
Yeah, Happy New Year.
Happy New Year to you as well.
How are you?
I'm doing well. Thank you.
Good.
How about yourself? Everything going well?
Very productive, busy, and yeah, making progress. And yeah, happy to hear from you. How can I be
Yeah,
of service?
Definitely. Well, I could definitely relate to the progress and definitely wanted to just check in. I guess two things that probably I think will be in your kind of court are, I know I'd previously just touched on having a suit with some ex business partners.
Mhm.
And basically, they filed two different motions, one being a demur. Yeah, this is their second time they actually filed a demur, and they're demurring to cause of actions I believe they kind of forewent in their first demur, that they didn't demur to those causes of action. So I believe that's improper. And they're also demurring to causes of action that the judge had already sustained, which I believe is also improper on their part. And they've also they're trying to do a protective order and basically cited some other cases that I've had and trying to say, well, I lost these cases and he's even incorrect in citing that I lost them. Yet he tried to tie this to a protective order where he's trying to get me labeled as, I guess, a vexatious litigant, yet he hasn't even filed the underlying protective order, just this RJN, citing different cases and incorrectly stating this RJN that I lost this case per se.
Okay, just as some background information, a demur is filed as a responsive pleading to the complaint. It is used to test the sufficiency of your pleadings. The test is, even if you were to take every fact as true, every allegation as true, does the complaint state a valid legal claim? Okay, so you are getting the presumption of the facts, your factual allegations being true. It's based on law. It's not about disputing the facts. It's all based
Right.
on law. So the common ground for asserting a demur is a failure to state a claim, all right? Failure to state facts sufficient to constitute a cause of action. Demur is a motion to dismiss. It's your first pleading. There's no evidence that will be evaluated. It's just based on the pleadings itself. And so what I gather from your fact pattern is their argument is that you are a vexatious litigant.
Well, that's in a separate motion. They tried to do a separate protective order. And so it's interesting. They had a lawyer and now they're claiming they don't have funds anymore.
Well, let me make it a point again. The standard of review is heavily in your favor. So in your reply, you really want to stress that the court is obligated to presume that everything you say is true. I mean, that's a very heavy presumption. It's
Right.
not about
Well-
disputing facts. It's just, have I laid out a claim?
Right. Well, because this is their second demur, the court already basically gave me, if you will, like kind of the pathway to success.
Did you amend
if you will.
yeah, after your first filing,
Correct.
did you have did you file an amended complaint?
Yes, sir.
Based on the court's ruling, their
Road
opinion?
path.
Did you file? Yeah, they basically told you what was lacking. And
Exactly.
so what was
Now-
what was lacking?
So for promissory estoppel, it was that I needed to simply allege that I had relied on their promise to my detriment.
As a
So-
practical standpoint, when you are drafting your complaint, refer to the civil jury instructions, the CACIs, CACI, and just use those elements. And if you use those elements, then you will satisfy your basis to state a claim.
Well, then I did have two additional causes, one being fraud and the other being extortion. And the judge stated on the fraud that I needed to, the judge kind of said that I believe it was incorrect, but stated that I was basing it too much on the breach of contract being a fraud.
Fraud
And I really did-
is a difficult cause of action to plead because you need to plead fraud with specificity. You have to have very specific facts. That means date, time, dialogue, what was actually
Right.
said.
And now that definitely gets into this, the part of the second demur that I didn't actually raise that I did want to mention to you too, because I was doing it with more the specifics, and because I'd also received some discovery from them regarding some of the causes of action, where the first part was I'd even received like a police report, and I know with 47B litigation privilege, you're generally not allowed to use per se a police report. What the statements they made, as that's generally protected under litigation privilege. But I understand in 2021, I forget which section it was, basically allowed if they did a false police report with malice, I believe, allows you to kind of sue for what normally would be otherwise protected under 47B, and especially after the 2021 amendment to that.
Okay, you're getting very specific with statutes that I don't know and they're not in front of me, so I can't really comment about that. If you've done your due diligence and you research, it sounds like you're presenting a very logical argument. I think you'll be just fine. But in terms of satisfying your standard of review to defeat the demur, refer to the civil jury instructions and copy them in your pleadings. Look, it's very, you, at this stage, because of due process, the courts are favorable or amenable to allow you to amend the complaint. So as an alternative, request leave to amend. You may even, in response to their demur, provide another updated amended complaint to your reply, saying alternatively, if the court is apt to rule in their favor, I'm here in good faith and good and clean hands. And here's another draft for the court to consider. And and if the court shall be so kind, allow me leave to amend and consider this updated complaint. I proactively did it in order to address the court's foreseeable concerns.
That's interesting. I like that.
Beat them to the punch.
Yeah. Well, the other thing I was going to mention was that I basically really briefly touched on was using discovery that I received that.
No, you can't consider evidence, demur. It's not based on evidence. This is not a motion for summary judgment. This is a demur.
Well, their argument in the demur was saying that I'm improperly using, they're trying to say litigation privilege of using their discovery responses that supported my claims to further support the claims, if that makes sense. They're trying to say that was improper. You can't use what's said in court, but my understanding
I don't know exactly what you pled, so I can't comment on that. But again, it sounds like you're going roundabout. I don't know if you're using something that was said by counsel that was in court, and that probably would not be proper. But again, the strongest thing in your favor is the standard of review. You take everything as true. Everything is as true. We're not here to dispute facts. They're true. For the purposes of considering this legal proceeding, the court must consider them to be true for me to get past this initial phase. We're not taking the case to trial, Jared, We're not arguing the facts here. Did you plead properly? That's the question. And if you follow the civil jury instructions, refer to the khakis for your cause of action, and then you can go into court and say, Your Honor, I copied the California civil jury instructions, word for word.
But
I'm pleading.
What I did in my
I'm pleading the elements for the causes of action.
And I fully understand what you're saying, but I may have taken it a step further by using in my complaint their discovery responses that supported my cause of action.
I don't know. I don't know how you used it. Did you attach their discovery responses as an exhibit? I don't know. I mean, that's. I don't know if that's improper. I'd have to review your complaint. But again, you're at pleading stage. All right, you're not. There's certain pleading standards to be met. In state court and federal court, there's different standards. There's notice pleading and there's fact pleading. Notice pleading is you just got to put them on notice. Fact pleading, you got to be a little bit more specific, and then maybe you want to have some exhibits and attach it. But in your situation, it may not be necessary.
Okay. And the last cause of action that I did want to mention was the extortion. And are you familiar with the Flatley v. Morrow case with the attorney kind of doing extortion? Well, that's what at least the court decided. Are you familiar with that case?
The case sounds familiar, actually. But offhand, I can't tell you yes or no, but
Got it.
I am well versed with the rules of extortion and attorneys acting ethically. Yes, it's a thin line. You can't,
Right.
yeah, you can't leverage a violation of a crime in order to
So,
get money payment.
right. So,
And
well,
all
basically,
the amounts all have to be reasonably related too if you're making a demand. Sometimes when I make a demand, I just don't even say an amount because you run the risk of committing extortion. And you can't leverage, well, I'm going to report you to the FBI or I'm going to go to the police unless you pay me.
and that's what happened kind of here. If you don't take our one and only deal, we're going to this agency.
Well, yes, if they said they're going to an agency, then yes, that could be considered extortion. It could be considered black letter extortion. But if it depends on how it was worded. If they said, if you're not taking our last offer here, we'll have no choice but to file a civil lawsuit.
No, this was get your behind locked up instantly.
Yeah, they cannot use that as a threat.
So I had basically used this additionally to as the second act of extortion they've done, and they're trying to state that using settlement discussions was part of their demur, which is kind of an admission to what they tried to do.
Yes, that's always the counter argument. This was in the course of a settlement negotiation. Was the correspondence labeled? Did they label it confidential? Was it labeled settlement negotiation? Did they refer to the evidence code? There's specific evidence code sections that I always cite to, and I make it clear. But even still, I don't believe that will relieve you from the fact that you committed extortion. I've handled a case very similar, and it's it could be considered extortion. And if it's coming from a lawyer, they're held to a higher duty.
It's not from a lawyer, so
Okay.
that's maybe a little different.
Mm-hmm.
But the other aspect, though, in the original demur ruling by the judge wanted to instill that there was actual property obtained. Now, and I tried to argue the Flatley v. Morrow case, but it didn't seem the judge was really receptive, where the threat alone constitutes, I forgot, the 518 or 523 penal code.
Mm-hmm. I am familiar with the Flatley case. That is the controlling case.
Right.
I have a lot of briefing on this situation. So perhaps you want to reach me offline and I can share what I have briefed on this. But I have handled situations like this.
Very fun situations, I'm sure.
Flatley versus Morrow. Let me see what I have here. It is a very fact-intensive analysis. The language will be scrutinized. Okay, it was written in a letter, I take it?
There was an email and text message that basically said, you take our one and only deal, or we go to this agency and get you locked up.
Okay. So, I mean, here is the main rule that I got out of that Flatley case is that it's case specific. All right. So the court said, we emphasize that our conclusion that Morrow's communications constituted criminal extortion as a matter of law are based on the specific and extreme circumstances of this case. Okay, so it's always a case-specific analysis. The court went on, extortion is the threat to accuse the victim of a crime or expose or impute to him any deformity, disgrace, or crime. That's the Penal Code 519, accompanied by a demand for payment to prevent the accusation, exposure, or imputation from being made. So it's the threat of going to the agency. Here's the main rule.
The payment, though.
Yeah, well, yeah, there must be that's key. There has to be a demand for payment.
Now here's the question. Does you take our one and only deal amount to a payment even though you're not sure of what the specific numerical?
Well, you bring a good situation. You bring up a unique fact pattern. And again, it's very case specific. All right. Because usually the money is flowing from the other way. All right. They're saying, take our money or we're going to the court or we're going to the agency. Usually it's pay me or I'm going to the agency. Okay. So
Right.
are they in fact extorting you? Perhaps.
Well, maybe the deal was, hey, we had a 10% agreement, and now our one and only deal is 0%. You walk away with nothing, and you don't go.
True.
So I don't.
That's why you have to argue that
you
have to argue the payment element is being satisfied here, because there is a transaction of money being demanded. But here's the main point here. The court went on to say, thus, our opinion should not be read to imply that rude, aggressive, or even belligerent pre-litigation negotiations, whether verbal or written, that may include threats to file a lawsuit, report criminal behavior to authorities, or publicize allegations of wrongdoing necessarily constitute extortion. So it's not always. It's a fact-intensive situation. So even if they make a threat, it's not necessarily extortion. You have to consider everything. It's about how they made you feel, whether you had a freedom of choice.
Right. I know that's very right.
And also, here's another key fact. Was there always an intention by the other party to engage in settlement negotiations?
Now, this is interesting. They had he sent me a text message right before this where he was like, we don't negotiate with terrorists.
Okay. And then also you talk about they're going to report you to the agency. What does that mean? What agency? Did they name it specifically?
They specifically stated
FBI, IRS.
No. He basically got me on probation and with kind of the reason why I'm suing him, and now he's trying to say I'm going to report you to the sheriffs and probation.
Did he name them specifically in his
specific?
All right, that's helpful for your case.
So I'm on pretrial probation, not actually, even found guilty of any crime, and it's.
So you can argue that is just merely a defensive litigation strategy rather than a genuine issue. They're just raising this matter of extortion as a defensive tactic. It's not a genuine issue, and there was no immediate coercion. Well, you are trying to allege extortion, right?
Right.
So they're going to be saying that you're using it as a tactic.
Now, it also seems though very witness intimidation, trying to. I don't know if that's a separate. Obviously, being the plaintiff per se, trying to threaten with obviously imprisonment if you don't take the deal. I don't know if witness intimidation is basically just within the realm of extortion in this scenario.
I'd have to get more facts as to the interactions between the parties. But I think this is a good point to adjourn. I think we discussed the issue thoroughly. I think you have some ammunition to go into a hearing to argue these points.
Most certainly.
But I would,
And I appreciate
again,
it.
but to argue to demur, perhaps have a second amended complaint ready to go in your back pocket if the court
Mhm.
is not in your favor. Have the case law that courts are very favorable to allowing amendment. All right, you got to have what we call these pocket briefs with the case law ready to go to present to the court to support your position. You just don't want your case kicked out.
Last question, if I may, real short. Do you believe having a court reporter is wise?
Depends if you have the resources for it. They're not cheap.
Oh, per se with a fee waiver.
I'm not sure.
Because then
I don't know.
you get them basically provided if you have a fee waiver. So
Okay, if you can get them at no charge, yeah, sure. Get a transcript.
okay.
Yeah, because look, I mean, you should be able to have the opportunity to amend it. It's your second amended complaint. How many times did the court?
I'm on the first I had amended before the demur, the first
Okay.
demur.
Well,
So
if they're
this is
going to
now the
dismiss it,
second.
request it without prejudice.
Right.
Okay.
I really feel I survived, and I think how they're actually demurring to what the court already overruled that's pretty bad faith on their aspects, and also demurring to like breach of contract and assault and battery that they actually did not demur to on their first demur,
I don't know.
which they had the opportunity to. So
Yeah,
I think that's all bad faith.
I'd have to review your docket and all the pleadings and what was filed. I do have to adjourn here. I'm here every Monday, 9 a.m. Great place to tap in and stay connected. And I look forward to seeing you next Monday. Take care, take action. Bye for now.
Thank you very much, Mr. Sterling.
Have a good day. Have a good week.
Likewise.